to Law Cora. This is an interactive platform where we all share our ideas, our legal opinions, our legal suggestions, and just discuss everything legal. So here is a community of those who are in the field of law or anyone who just enjoys the legal aspect of life and wants to learn more about the law. Here's a platform where we interact and share our ideas. So, in the last episode, we briefly introduced the meaning and the purpose of this podcast and what our aims and objectives are, the reason behind the creation of this podcast. And so today we're going to be discussing a very important topic, which we will be defining what law is. This our podcast is named Law Cora, and so there's no way we can start talking about the other aspects of law, discussing about the other aspects of law, like the criminal law, the constitutional law, administrative law, evidence law, oil and gas law, labor law, jurisprudence and the rest, without knowing what law itself is. So we are going to provide a definition of law, but however, it is worthy to note that there is no universally accepted definition of law. So my own definition of law would just be from my own opinion, from my own perspective, and also applying, the general elements of what the law should be. But there's no globally recognized definition of law. So first and foremost, I'll start by defining law according to the Black's Law Dictionary. So according to the Black Law Dictionary, 6th edition, law is a body of rules of action or conduct prescribed by a controlling authority and having binding legal force, that which must be obeyed and followed by citizens, subject to sanctions or legal consequence, is a law. I repeat, according to the Black's Law Dictionary, 6th edition, law is a body of rules of action or conduct prescribed by a controlling authority and having binding legal force, that which must be obeyed and followed by citizens, subject to sanctions or legal consequence, is a law. So that is the definition of law according to the Black's Law Dictionary. So now I'll be providing some definitions of law according to some eminent jurists, philosophers, and legal scholars. So, according to Herman Max Gluckman, 1991 to 1975, he defined law as the whole reservoir of rules on which judges draw for their decision. According to Sir William Blackstone, he defined law as the rule of action which is prescribed by some superior and which the inferior is bound to obey. According to Aristotle, he defines law as the office and punishment of offenders. According to St. Thomas Aquinas, he also gave his own definition of law. He said law is an ordinance of reason for the common good made by him who has care of the community and promulgated. When we say promulgated here, we mean formally made public. So that's what promulgated in his definition means. Also, there are other definitions of law according to some jurists. Okay, so John Austin, he defined law as the command of the sovereign or the superior over the inferior, backed by sanctions. According to Kant, he says that law is the aggregate of the conditions under which the arbitrary will of one individual may be combined with that of another under a general inclusive law of freedom. According to Theorin, he opined that law is the sum of the conditions of social life in the widest sense of the term, as secured by the power of the state through the means of external compulsion. So we can go on and on and on and give many definitions of law according to various authors. There are a million of them who has given their own definition of what law is or what law should be. But like I said earlier on, there's no universally accepted definition of law because law is very complex. Law is very complex. So what may be regarded as law to a particular society or to a particular community may not be regarded as law in another community because there are divergent ideas. People have divergent ideas. They have different beliefs, different principles, different moral standards. So the law cannot have a universal definition that will cover every society or that will cover every region or every race. So law is applicable to a particular society. So what may be regarded as law to Mr. A may not be regarded as law to Mr. B. And also in the future, due to technological advancements and as the society advances and develops, what may have been law in the past may no longer be law again in the present. What may have been seen as this is what should be so may, due to the changes in the society, people's moral beliefs tend to adjust and tend to change. So what may be regarded as law in the 19th, 18th, 17th century may not still be applicable because the world is growing and new technology is coming. So laws need to reflect the current happenings of the society. So that is that for the definition of law. We have handled what law should be, what we feel that law would be. So now let me give my own definition of what I think the law should be. So just like we have listened to various jurists, I believe that law is a system of rules. Law is a system of rules that is made by a legal authority. When I say legal authority, I mean by those vested with the power to make laws. So law is a system of rules made by a legal authority and that is binding on the people. And that is also backed with sanctions to ensure compliance. So I said that law is a system of rules made by a legal authority that is backed by sanctions to ensure compliance. Now, law must be backed by sanctions because the people ordinarily, some people might decide not to obey the law. Some people might feel that they are above the law. Some people ordinarily would not want to obey the law, but because of the sanctions attached to it, because of the punishment attached to it, they are now forced and compelled to behave civil and to work in consonance with the law. So if you remove that sanction, if you jettison the sanction, the people would feel, they wouldn't feel the need to obey the law because they will assume that whether or not they obey the law, that they are going scot-free. Nothing will happen to them. Nobody's coming to punish them. Nobody's coming to sanction them. There's no adverse effect. It's more like morality. You understand? It would be more like a moral belief, a moral code. We'll get to morality later. So law has to be backed by sanctions to ensure by a constituting authority. Law cannot be made by anybody. There have to be a defined body that is reserved for making and constituting the law. Because if everybody is making the law, the society will be disorganized. We won't say, okay, this is the body vested with the power of making laws, and so this particular law you made is in consonance with the people, is not in consonance. We won't be able to pinpoint. We won't be able to know who directly to address our law-making issues to. So there is need for a constituting authority, a legal authority, like in most societies. In most democratic societies, there's the legislature. So the legislature, remember, we have three arms of government: the legislature, the executive, and the judiciary. So the legislature are the ones vested with the power of making laws. So there need to be a body vested with that power to make law, not just anybody. And finally, is to ensure compliance. All these backed by sanctions, constituting authority, all these are to ensure compliance, because without those, they cannot be able to achieve compliance. Without those, you cannot be able to achieve compliance. It's just like wanting to cook indomie. Without water and without gas, you cannot cook the indomie. So the indomie will still be raw as it is. So water and gas is needed for the indomie to come out nice. So that is the same way sanctions and a constituting authority is needed to ensure compliance. So that is my own definition of law. That is what I think law should be all about. So that's for the definition of law. So we have talked extensively on the definition of law and given the definition according to various authors, their own opinions of what the law is. So now we'll be moving straight to the classification of law. Law has been defined, but law still has its classifications. So there are different classifications of law which we would use to say, okay, this is this type of law and this is where and when it applies. So in the classification of law, we have the public and private law. Another classification of law is the civil and criminal law. Another classification of law is the procedural and substantive law. Then another classification of law also is the municipal, national, or domestic law, and also international law. Another classification of law is the written and unwritten law. And finally, the last classification of law I'll be giving is the common law and equity. So I classified it under 6 categories. So these are the classification of law. So now we'll be talking about the public and private law. Now, the public law are laws that regulate relationships between the state and individuals or agencies. It is the aspect of law that deals with the relationship between the state and citizens, and this the public law includes the administrative law, the constitutional law, the criminal law, international law, so on and so forth. Now, for the private law, these are now laws that govern relationship between individuals. For the word private, you know that is relating to individuals and not relating to the states. Criminal law, for instance, is an example of a law that is between the individual and the state. Because a crime is seen as an offense against the state, so the state will take up the matter. Especially in cases like rape, murder, those kind of cases. So the state will take it up. So example of private law includes the law of contract, family law, law of torts, law of succession, marriage act, etc. That is under the public and private law. So now under the civil and criminal law. Now civil law, when we talk about civil law, this is just talking about anything that's not criminal law. You get, civil law is just anything not criminal. Civil law defines the rights and duties of persons to one another rather than dealing with criminal offenses. So example of this civil law is the law of contract, the law of tort of defamation, family law, land law, etc. Now, criminal law, on the other hand, criminal law seeks to protect the interest of the public at large. So, criminal law is it happens between is a kind of when these kind of crimes are committed, it happens between individuals, but the state takes it up. Like I said earlier on, when I was explaining the public law. In criminal law, this is a crime that is committed between individuals in society. But once a crime and is committed, the state takes it up because a crime is seen as an offense against the state itself. So the state is there to represent the victim in the particular case. So it's a type of law that seeks to protect the interests of the public at large. So the essence of the state taking up these criminal cases is because it is very necessary because it is to maintain order in the society, and it is not done. The rights of some individuals may be trampled upon, especially the vulnerable, the common man, those who do not have the wealth and the connections to be able to properly fight for themselves. So that is why the state takes it up. So that's that's for criminal law. And under this criminal law, we have the criminal code and the penal code. The criminal code applies to the east, the southeast, and the southwest in Nigeria. While the penal code applies to the north. So what may be regarded as a crime in the south may not be a crime in the north. So it is very important when one is having a case or having any issue, you should know your jurisdiction and know what is a crime in its particular society. So criminal offenses are usually backed by sanctions. Serious crimes, for example, like murder, treason, armed robbery, etc. Those kind of crimes they are backed by sanction. Those kind of crimes are backed by sanction. So, and another important distinction between civil wrong and crime is that in criminal trial, the prosecution has to prove beyond reasonable doubt. Why for a civil wrong it is called balance of probability. So this is a major distinction between criminal law and civil law. In criminal law, the burden of proof is on the prosecution. So the prosecution is there to prove beyond reasonable doubt to the court. Whereas in civil law, what the court is looking on is the balance of probability. That is a major distinction between the criminal and civil law. So, however, there are some crimes that may also constitute civil wrong. They may have both civil and criminal elements. For instance, defamation and assault. They can be both criminal or civil. Example, battery. So those are kind of crimes that may have criminal and civil elements. So the next classification of law we're going to be looking at is the substantive and procedural law. So the substantive law is the law that prohibits the doing or not doing of certain things. This law prescribes the code of conduct. Now, a breach of this substantive law may involve fine or imprisonment. So examples of this substantive law include the law of contract, constitutional law, criminal law, etc. So substantive law, like we have said, it tells you what to do and what not to do. Substantive law, it tells this is what is right and this is what is wrong. So a breach of which would attract fine or imprisonment. Now, the procedural law, on the other hand, deals with proceedings to enforce certain rights and how the litigation is being done. So it is this procedural law that will explain the rules and procedures of how the law operates. So we can simply say that procedural law is a law procedural law sets the law in motion. You understand? Procedural law sets the law in motion. So it explains the rules and procedures of the law. Examples of this procedural law includes the FREP rules, the Administration of Criminal Justice Act, and the Criminal Procedure Code and the Criminal Procedure Act. These are examples of procedural law. So when we're talking about substantive and procedural law, we need to know that substantive will tell you this is what to do and this is what not to do. Whereas procedural, from the name procedure, is just there to tell you how it will be done. This is how you would do this, and this is the way you would do that. So that's the major distinction between the procedural and the substantive law. So now the national and international law. National law, as we all know from the word national, it deals with laws within a state or nation. So it governs the relationship of people in a nation. National law deals with the laws that are applicable to a particular nation or a particular state. Whereas international law, it governs the relationship between nations at international levels. For instance, if to be laws that are governing the relationship between the the members of the ECOWAS or the members of the United Nations. So those are international laws. So examples of international laws include the Universal Declaration of Human Rights, the UDHR, also the International Convention on Economic and Sociocultural Rights, that is the ICESCR. Also the Convention on Rights of Children, the CRC. And these are many more examples of international laws. So moving forward, we'll also talk about the written and unwritten law. Written law, these are laws that are codified and documented in a statute. An example of written law is the Nigerian Constitution, the Criminal Code. These are written laws, whereas unwritten laws, these are laws that cannot be found in any statute. And a major example of this unwritten law is the customary law. Customs of the people most often are not documented and they are not codified. Though some customs may be codified and some customs may be written down, but majority of the customs practiced in different societies, in different regions, are mostly uncodified. So that is an example of unwritten law. So like I gave examples of written law, it includes the Constitution, Criminal Code, Penal Code, Sales of Good Acts. Any law that is written and codified is a written law. An example of countries that are practicing written law is Nigeria. And an example of societies practicing unwritten law can be the United Kingdom, the UK. So that is the distinction between written and unwritten law. So in our next episode, we're going to discuss the remaining classifications of law. We're going to marshal them out, and after talking about them, we will now discuss the sources of law. Then from there, we would forge ahead. So I hope you enjoyed this episode. I hope it was educative enough and that at least you were able to grab some important ideas on understanding the meaning and concept of law. A brief summary of what we have done today is we have defined law according to the Black's Law Dictionary. We define law according to philosophers and eminent jurists. We also I also gave my own definition of law. Then we moved to the classification of law. We highlighted the different classification and we explained in detail some of these classifications. So in the next episode, we'll deal with the remaining classifications, then move straight to the sources of law. So I hope you enjoyed the episode. Stay tuned and follow this podcast for more educative legal contents like this. And make sure you share with your friends and family and let them know that there's a community like this where people can interact and share their legal opinions and just know about the legal sphere of the society, what is the future of the legal scope of the society. So do well to share your comments, and we'll soon be opening a YouTube channel so that those who use YouTube often can also follow our podcast on YouTube. So we hope this podcast was educative as as possible. And please note, I am not a lawyer. I am a law student. So everything in this podcast is mainly for educative purpose. Please do not take any of it for legal advice. If you are seeking proper legal advice, please consult your lawyer for proper legal advice. So thank you once again and do have yourself a great day. Bye.